Hi, everyone. My name is Berin S, Romagnolo, and I head the business immigration practice here at Errant Fox Ship. This is our third episode of my Berin's Business Immigration Breakdown series. Thank you for joining me. I have in the contacts and the events link my contact information. This is a quick afternoon break, just about 15 minutes to go over what is new and noteworthy in the business immigration world. So to keep it moving and to keep everyone's information private, I have my email address in the link. So you can email me any questions you want. I also have in the comments section to the events page some helpful links for you that are relevant to the topics we're going to be talking about today. Let's talk about what that is. So again, we're talking about the new and noteworthy. Today's topic is citizenship discrimination and document abuse I-9 compliance. Why is that new and noteworthy? Well, we have noticed that recently the Department of Justice has increased their enforcement action and for employer compliance. We have seen an increased number of investigations, lawsuits, audits from the Department of Justice and other government agencies regarding these topics, with big civil penalties and other ramifications for the employer. So we thought we would cover it here to see if I can give you some tips for pre and post hiring practices that can keep you out of danger. First topic, citizenship discrimination. What does that mean? It means that employers cannot take an adverse employment action against a candidate or an employee based on four categories. They cannot take adverse employment action against a U.S. citizen, a green card holder, a refugee, or an asylee. Those are the four categories of people that are protected under the federal law for citizenship discrimination. That means H-1B work visa holders, F-1 students, O-1s, TN visa holders, all other work visa holders are not protected under the federal citizenship discrimination statute. That does not mean they're not protected. You cannot discriminate against anyone based on national origin or race or ethnicity, but not under the citizenship discrimination statute. So what that means for employers is that you can decide to restrict sponsorship. You have no obligation as an employer to sponsor anyone for a work visa or for a green card. That does not violate any law. You have the right to decide as an employer, as a business, if you want to sponsor someone for a work visa or for a green card. You can decide to say in your ads whether or not a job is eligible for sponsorship for a work visa. You can decide to say in ads whether or not citizenship is a requirement for the job, but we'll talk about when that is allowed and when that becomes discriminatory. ITAR and export controls also come into play here. Many jobs are restricted in the United States in the way that some jobs, if you have access to certain technology or you're from a certain country, you may need to have a license before you're allowed to do that job. Employers are not allowed to discriminate against candidates based on ITAR or export control requirements. So you cannot restrict candidates based on that. All that means is that the law requires you to get an extra step, an extra license before that candidate is allowed to work in a particular job. That is one big area of enforcement recently. The other big area of enforcement is document abuse and I-9 compliance. What does that mean? That means that employers are not allowed to tell employees what I-9 documents they should present when they're filling out the I-9. The I-9 is the federal form that every employer in the United States has to give to every employee that is working for pay in the United States. And that employee has to complete their section, and the employer has to complete their section within 3 days of the first day of paid employment. That I-9 form requires the employee to show to the employer a document that proves their identity and a document that proves their work authorization. It can be one document that proves both, but you have to prove both of those things, identity and work authorization. Document abuse means that the employer cannot tell them what documents they are required to show you. It means that you can't, as an employer, refuse a document that they give you if it's an acceptable document. And it means that you can't ask for any additional documents if they give you an acceptable document. So what you're supposed to do as an employer is give the I-9 form to the employee, give them the instructions, and give them the document that is called List of Acceptable Documents. That list is a federal list that tells them all the acceptable documents they can use to fill out the I-9 form. That is all you're supposed to say. You are not supposed to say, oh, I see you're a green card holder, let me see your green card. You're not supposed to suggest which documents they should give you. You're not supposed to ask for additional different documents that they're supposed to give you. This has been a hot topic with the governments recently for enforcement action. So I wanted to cover that today to help you figure out tips so that you don't fall into any of the traps there. Let's talk about the recent enforcement action so you can get a sense of what topics are coming up, how they're coming up, how to avoid it for you, and what the penalties have been so you understand the severity that it could mean for you. And these are all very recent cases in the last handful of months. Okay, so Apple. Apple recently settled a case with the Department of Justice for $25 million for citizenship discrimination. The Department of Justice were alleging that the Apple has been discriminating against U.S. citizens and favoring foreign national workers in their green card process. In the green card process, the first step requires the employer to advertise the green card job and prove to the Department of Labor there's no qualified U.S. worker for the job. When you're advertising, the government has a list of regulations that tells you where to advertise, how long to advertise for, what should be included in the ads, how to respond to the ads, how to screen the applicants. All of that is covered by federal regulation under the PERM green card rules. Apple, when they were doing their advertisements for the green card jobs, only allowed applicants to reply by mail, did not include a link for an electronic resume submission or an email where they can scan an email, a resume, or cover letter. Everyone was only required to apply by mail, which the government decided gave a chilling effect because it was such a higher burden for people to apply by mail. It deterred workers from applying for those green card jobs. They thought that that was discriminatory against U.S. workers and favored the foreign workers that they were trying to protect. They also said that the ads did not run in the Apple's website, their external website. And they said that Apple normally would have run their job ads on their website, but they didn't for the green card job. So they didn't expose the workers, the applicant pool to that ad through their website and didn't follow their regular protocol for regular recruiting practices. Department of Justice also said that Apple did not consider some internal Apple candidates that applied for the green card job, that they didn't consider them, which is different than what they would normally do in a regular recruiting process. Those are the main things that the Department of Justice said happened in the Apple case that they alleged were discriminatory in violation of citizenship discrimination laws. They settled for $25 million, and the settlement required Apple to start putting in all of their green card ads an email or a link for electronic submission of applications. They required to put all of their submissions into their regular electronic applicant database and tracking system. They required all green card ads to be posted on internal and external Apple websites, just like other ads normally are for them. And very significantly, they required Apple to send in reports semi-annually to the Department of Justice to show that they are continuing their compliance efforts. And the Department of Justice will continue to monitor them for those compliance efforts, which means they're on their radar. They also had to do some training for their recruiters and internal workers to make sure that everyone understands what the requirements are, what they can and can't say, how to stay clear of discriminatory practices. That's one big recent case. Here's another one. SpaceX recently got sued by the Department of Justice for discriminatory practices and I-9 violations. In that case, they said that they had ads, SpaceX ran ads that said only U.S. citizens and lawful permanent residents were allowed to apply, restricting everyone else from applying for the job. They said that was discriminatory because the federal law says that U.S. citizens, green card holders, refugees, and asylees, all four of those categories are protected from citizenship discrimination. So you can't restrict out the refugees and the asylees from the applicant pool. SpaceX said, I restricted them out because I have export control and other restrictions that require sensitive information to be restricted from some of the categories. And this is what they're litigating, and you have to steer clear of those kind of requirements because, again, the ITAR and export control rules do not say you can restrict the applicant pool. They just said you need to get an extra license if you want to hire them into certain jobs. One more category of cases I wanted to go over with you so you can see the level of penalties that might be coming your way if you run afoul of these rules. There's a security company and trucking company, two different companies, two different cases, but similar topic that has been the topic of enforcement action by the Department of Justice recently. They have a practice of requiring or asking for additional documents from their employees when they're completing the I-9 process. For example, someone may say on the I-9 that they have, and they check the box that says that they're a lawful permanent resident. But then when they fill out the I-9, they show a social security number and a driver's license, as they're allowed to do under the list of acceptable documents. Well, in these cases, the employer may have said, you checked off green card, I want to see your green card. Where's your green card? You're not allowed to say that, says the Department of Justice and say the I-9 rules. And they find that to be document abuse and I-9 violations. You can't ask for additional documents. In the security company case, they were fined $100,000 in civil penalties and $75,000 in back pay. The trucking company was fined $700,000 in civil penalties. They also had to do some training programs to stay clear of these discriminatory practices and I-9 violations, and they're also on the radar for continued monitoring from the government. So this is why it's important. This is why I brought it up to you. Let's talk about some lessons learned that you can take on for your own employment practices and training purposes. The PERM process, the green card process, should mimic the recruiting practices that you do for everyone else. So if you usually allow applicants to apply by email or through a link or an electronic system, you should do the same for your green card job applications. If you usually have an internal posting, an external posting on your website, an intranet posting, employee referral program posting, all of those, if those are your normal practices, that's what you do for your green card postings. So that everything mimics what you normally would do as close as you can and as it's relevant to the case, so that you're not favoring any one group of people based on citizenship status over another. If you have a job that you think requires an export license, make sure you ask all applicants about their citizenship status, not just a certain category, so that it is a blanket rule that applies to all applicants, so you're not singling out anybody based on citizenship status. Be careful if you ask about citizenship status for ITAR or export control purposes, because when they give you their country of origin, that could lead to a national origin discrimination claim. If you fail to hire someone after they say they're from a certain country, that foreign national may perceive that their failure to hire was based on their national origin and bring a claim. So it's a very dangerous area to be in. Tread lightly when you are asking additional questions for export control purposes. In ads, be careful about what language you use about restricting the applicant pool. Be careful that you only say U.S. citizens only if you have a government contract that explicitly says U.S. citizens only. Make sure that you don't ask in the ads for something that is a lower applicant pool than what is allowed under government contracts or under federal law, regulation, or executive order. Do not ask for any I-9 documents beyond what is on the list of acceptable documents. Give them the form and the list, let them choose what they want. As long as it's on the list, you accept it, and as long as it looks legitimate on its face. You cannot run E-Verify pre-hire. You cannot put them into the Verify system until they fill out the I-9, which is after offer and acceptance of the job. And you cannot put their social security number into the social security verification system online pre-hire. All of those have been found to be discriminatory. What can you do pre-hire? Well, you can ask two main questions to an applicant pre-hire. You can say, are you authorized to work in the United States? question number one. And question number two, you can say, do you now or will you in the future need sponsorship from this company for work authorization? For example, H-1B sponsorship in the future. You're allowed to ask those questions. The Department of Justice has issued letters and technical assistance guidance telling us that that is allowed. In the link in the comments is a link to all of those Department of Justice technical assistance letters, and you can see the language there. If you have a job description that says that is not allowed to be eligible for work visas, make sure the ad is clear in how you say the restriction. Make sure the ad says something like, this job is not eligible for work visa sponsorship, so that it's clear to the applicant that if they're not hired, it's not because of their national origin, it's just because you're exercising your right as an employer not to sponsor someone for a work visa. Make sure you don't restrict the job ads to people that are only from certain countries or are not from certain countries. Make sure you don't ask applicants for unrestricted work visas only, because that unlawfully restricts refugees and asylees. Refugees and asylees may have a work authorization card that has an expiration date that looks like it's a restricted work authorization, but it's not. They have work authorization incident to their status, so it's continuous. So if you restrict your applicant pool to only those that have unrestricted work authorization, you will be unlawfully discriminating against refugees and asylees. Do not ask for identity and work authorization I-9 documents pre-hire. You can only ask for those after offer and acceptance of the job offer. What can you do after you offer the job and they accept it? What can you do post-hire? Well, now you can do the I-9. Now you have 3 days from the first day of paid employment to complete the I-9 form, get the I-9 documents from the employee and inspect them and fill out the form. You use that form to fill out the E-Verify form online if you are enrolled in E-Verify. If you have to do a screening for export control or ITAR compliance, the government has said that that export control screening process has to be separate from the I-9 process. They have deemed it discriminatory to combine them and use I-9 information for ITAR purposes. So you have to have two separate processes, and the documents have to be kept separately. They probably should be asked by separate people, and the form should be separate. Let's talk about some common situations that might come up post-hire. What if you said on your job application, do you now or in the future need work visa sponsorship? And someone says no. But then later on, you find out that they actually do. What can you do? Can you rescind the offer? You do have the right to rescind the offer. You run the risk of some claims by the employee, or maybe detrimental reliance, meaning maybe they forewent another job offer to take your offer, relying on your promise to give them employment. There might be other claims. So you can rescind, but you might be at risk for some claims from the candidate if you rescind the offer. When might this come up? Well, sometimes there is a foreign student who's an F1 student who has work authorization after graduation, a 1-year work authorization after graduation shown by an EAD card. What if you hire them and you hire them for a short-term project or an internship or something like that? So they say, I don't need sponsorship because that EAD card covers them for the period of time that you thought they were going to be working for. But then when they started working, they were a rock star. They were great, and you wanted to continue to employ them after, longer than that. Well, their EAD card is going to expire. Now they're going to need work authorization. Now what do you do? Well, you as an employer always retain the right to decide whether or not you're going to sponsor someone. So you can later on decide, excuse me, that you're not going to sponsor them. You can later on decide that their work authorization was great for the project they were hired for. You're not, as an employer, going to keep them on because continued employment would require the company to sponsor them for a work visa. What if you hire someone and they say, nope, don't need any sponsorship. I have an EAD card because of a pending green card process. And you see the EAD card, you see that it has a code on there, which is C09, that shows that it's part of a pending green card process. True, they don't need you to sponsor them for work authorization because the EAD card is their work authorization. However, if that pending green card process is an employment-based green card process, then it is possible that you as the employer will have to file a form called an I-485J with the government to be able to continue the green card process and transfer it to you so that they can continue working under that pending green card process. So sometimes it is tricky, and sometimes an employee will check off, nope, I don't need sponsorship, when in actuality, they may need something from the employer later on. If that happens, it is possible for the employer to rescind the offer or reconsider whether or not the long-term relationship is going to work out. Let's talk about some last lessons to take with you as you move on in this pre and post hiring practice area. Number one, I would train all your recruiters and everyone involved in the hiring process what they can and cannot ask employees, what they can and cannot require from candidates about documents pre-hire and about their citizenship status pre-hire. We should review your job ads for any discriminatory language, any restrictive language. Review your job applications for the same thing. Review the job applications for the questions that you ask to see if it is unburdened, if it burdens the employee too much and the candidates too much, and see if it restricts candidates from applying unlawfully or discriminating against them unlawfully. Train your I-9 completers to make sure they know how to properly complete the I-9 process. So they're not asking for additional documents, new documents, different documents than what is required under the I-9 process. Make sure you separate your ITAR and export control process from your I-9 process so they're not commingled and don't run afoul of any of the discriminatory rules. Check your government contracts to see if there truly is any language in there that restricts the applicant pool, so that you know that if you're going to put something into a job ad or if you're screening out people, it's really truly based on a true legitimate requirement from a government contract that requires it. And lastly, be proactive and do a I-9 audit, or at least a random selection of your I-9 audit, so that you have some faith that that the I-9s have been completed properly, fully, comprehensively. All employees have one, none are missing. And that will give you the good faith defense so that if you become subject to a Department of Justice or ICE or any other audit or investigation, you're in a good place. You can show that you have done a proactive audit. That gives you the good faith defense that you have tried to comply, that you've made corrections and fixed them beforehand so that you get credit for those corrections from the government. And that will help you avoid all the penalties that we've been seeing from the government. Thank you for joining me today. I hope this was helpful. It's a lot of nuanced stuff, and so it's very also fact specific. So if you have cases that may not fall into the general rule, maybe they're very nuanced, maybe they're very specific to a particular situation or a particular contract, feel free to email me. Again, my information is in the comments to the events page. I'm here if you need me.